Welcome to Rock Solid IP, expert strategies for creating real value from your creativity and innovation.
Hi, and welcome to Rock Solid IP, expert strategies for creating real value from creativity and innovation. I'm Kendall Trosky, and I'm here today with attorney Rob Wells from Rock IP Law Firm in Washington, D.C. Hi, Rob. How are you today?
Great, Kendall. Thanks for having us.
Wonderful. Welcome. Well, I'm going to kick this off right away and ask you, what is a trademark?
Terrific question. So a trademark is designed in intellectual property worldwide to protect the public's ability to recognize the source of products and services. So it can be just the name. So for example, Coca-Cola, just the word Coca-Cola or Nike. It can also be the way that it's organized, the logo or a design patent. All of those things can be considered a trademark. It can also be other things. For example, you might recognize the red bottom of a Louboutin shoe and know that that is a trademark, that color on the bottom of a woman's shoe is trademarked. You might recognize a nice light blue color in a box that represents Tiffany's. Colors can also be trademarked. So can sounds, so can certain aromas and different tastes. Those can all be trademarkable. If it identifies the source of a particular good or service, it can be trademarked.
Interesting. They come in various ways. What are some of the misconceptions that startups have about trademarks?
One of the biggest misconceptions that startup companies have about trademarks is that they kind of get the order wrong. They come up with the idea, they come up with the name, they come up with the brand for a new product or for their company. And then they come to the intellectual property attorney and ask to trademark it. That's kind of the wrong order. The better approach is to have your marketing team or for you to go ahead and sit down and come up with a few different possible names to try to identify a few possible trademarkable names and to approach your patent attorney who can then go ahead and help you with what we call a naming project, where we do a broad cursory search to see which ones are strongest and which ones are potentially available to you. Once you make a choice about which ones are potentially available, then we do what's called a clearance search. That's where we make sure that the name actually is available. A clearance search shouldn't just be and is not just searching at the USPTO. It's also not just making sure that you can get the business name at your local state or in Delaware. It's a matter of searching, yes, all of the business records, and yes, all of the federal trademark registrations. But it's also a matter of checking every other state's trademark registrations and looking just in to see if somebody is using a mark anywhere that we can find. Because a trademark actually doesn't require a federal registration in order to exist. A trademark exists as soon as you start using it to sell and identify your products and services. So unfortunately, there are some businesses that have never protected their trademarks, and that doesn't necessarily mean that the trademark doesn't exist.
Interesting. So what is the difference between trademark, copyright, and patent?
So a patent protects the actual how, the actual technology behind your idea, the actual function, or at least the ornamental design, the look and feel of an object. A trademark protects the public's ability to recognize the source of a product or service. And a copyright protects the artistic work of an author or a designer or an artist.
What essential steps for a startup to register their trademark?
The first step is to choose your trademark. And that involves, it's a bit more nuanced, and I think a lot of startups really respect. So let me go in and explain the levels of distinctiveness and how to choose a really, really strong trademark, because that's ultimately what you want your brand to be. In choosing a brand, there are 5 typically levels of distinctiveness. The first level of distinctiveness is what is called fanciful, a fanciful mark. That's a word or a term that doesn't exist anywhere yet. Those are terms like Google or Xerox or Kodak. They didn't exist anywhere in the English language or really anywhere in the human language before they were created. They're non-existent. Those terms are the most fanciful, and they're the strongest brands. Then there are arbitrary terms. Arbitrary terms are terms that certainly exist in language, but have no bearing on or indication about what the product itself is. Those are terms like, again, Dove or Uber or Camel for cigarettes, those types of terms where, a Camel has nothing to do with a cigarette and Uber has nothing to do with ride sharing, but they get used as a brand name. And as a result, they are still, while not fanciful, still very, very strong marks. The next level is one that's suggestive. It requires a little bit more thinking maybe to make the connection, but there may be some indication as to what the good or service is. So for example, you would have like Chicken of the Sea for tuna, or you would have Trek for bicycles, or you'd have 7-Eleven for a convenience store that tries to be open all the time. Those are suggestive marks. Again, they can be fairly strong and they can become more distinctive over time, especially. The next one is a descriptive mark. This is where you actually use a name of or a term that is relevant to your field and kind of directs the mind of the public towards the product or service that you're offering. And this is where a lot of our clients come in. They want to find something that, tells the public exactly what they do. They're a health food store, so they want to include the words health food in their mark. They're a bank and they want to include the word bank in their mark, or they want to have something related to value, or they're a tax company and so they want to include the word tax. Those all become descriptive terms. They describe some feature about your service. They're lower on the level of distinctiveness. And then we get to generic marks. Generic marks are the ones that unfortunately they explain exactly what your product is and what your product does. Those are marks that have no distinctiveness at all and that the Patent and Trademark Office won't let you protect. That's, for example, like calling your company the computer store when that's what you do. You sell computers. It will be pretty difficult to protect that.
Well, I've seen some people, you look at, like we said, Nike. Nike's doesn't have anything to do with shoes.
That's correct.
So doesn't describe it at all. How long does the process usually take?
The process can vary, but it's much faster than, for example, patents. Typically right now, what we're seeing is, and it depends on the backlog at the USPTO, but right now we're seeing about 12 to 14 months from the time that you file your trademark application until you actually have a registered trademark.
When should the startup consider trademarking the brand?
There's two different kinds of trademark applications when you file. You can file your trademark as either an actual use trademark, meaning I'm actually using it right now and selling products and services with it. You can also file it as an intent to use application. When you file it as an intent to use application, that means I'm not using it just yet, but I plan to probably sometime in the next year to 5 years. And so you can get clearance on it early on in the process. We recommend for our clients to get trademark protection as early in the process as possible, at the conception stage, at the idea stage, rather than trying to do it once they're already selling their products and services.
And your firm can help them determine the availability of their trademark. We said that a little earlier, I believe.
That's right. We strongly encourage our clients to first run if it's necessary, a naming project to identify the name that they want to use or the logo that they want to use, and then to run a clearance search that will fully clear and vet your name. It doesn't give you 100% clarity and knowledge that you are the only person, that nobody's going to pop up out of the woodwork and somehow have been using your mark, but it gets you pretty darn close. Nothing can get you to 100%, right? But it does get you to 95%, and that is good enough. And then we can help our clients to go ahead and file their trademark applications.
How can a strong trademark contribute to a startup's overall branding strategy? If
your trademark is narrow, if you have just a descriptive mark, there's not as much room for you to be able to protect it and to be able to go after potential infringers or people who kind of are encroaching on your space. There are too many potential options for people to use to kind of get close to your mark, and becomes less distinctive. The goal of a trademark should be to be as distinctive and iconic as possible, so that when you're spending money in brand recognition, when you're spending money to make sure that to market and make sure that people recognize your brand, the public recognizes your brand as being as distinctive as possible. So one of the key things startup companies can do is to focus on choosing distinctive marks that will be valuable. Then the next thing that you do need to do once you have a trademark is you unfortunately do need to spend time and effort, probably some money, enforcing your mark, making sure that you monitor the public and monitor the marketplace and identify people who are potentially infringing on your trademark, and then to go ahead and enforce that.
And you were going to take that. That was another question I was going to have for you about how are some of the common challenges of enforcing your trademark. And what if a company runs across a trademark that they want, but somebody else is using but is not trademarked it?
If a company is using a mark but hasn't actually trademarked it and received a federal registration, the best approach is to not go ahead and to try to trample on their ground. If a company is using a mark, it is their trademark. So when a company, you might have seen the little superscript that either says TM or has an R inside of a circle. When it has the TM, that means that it's a trademark, that they're using it as a trademark, but it may not be federally registered yet. If it has the R with the circle around it, at least in the United States again, that means that it is a federally registered trademark. But even without the TM or the R, you can still have the name of a business. You can still have a trademark. So it's best not to try and infringe. It's not like a website domain name that you can just go ahead and register before your competition can, and then you control it.
Okay, so you wouldn't recommend them to use it if somebody else is already using it, even if they haven't trademarked it?
If somebody else is using your mark and they're using the mark that you want, and they're using it inside of the same goods and services that you are trying to sell your product in, then I would recommend not going there. Just stay away, because it only invites problems.
And what would the repercussions be if you were not in the same industry?
If you're not in the same industry, then you can consider using the same mark, as long as they're far enough apart and as long as there is not a likelihood of consumer confusion, as long as people, the public, wouldn't likely be confused as to who manufactured or made or offered the service or product for sale.
Okay, so going back, the best way for a startup to proceed is when they come up with the idea for a trademark, come up with several, and then come to you, and you will go what step by what step to get them to decide on which trademark is best for them.
That's right. Either come to us with one name that you want to protect, or come to us with what we call the naming project with a few different names that we can help clear. And then to go ahead and we will run a clearance search and make sure that that mark is available for your goods and services. And then we'll go ahead and help you file a trademark application, at which point hopefully you'll get a trademark and you'll be able to continue using it and put that little R at the top of your logo or your word instead of just the TM.
Do you ever have anyone come to you and ask you to help create one?
We do, and we can help to identify potential names, but ultimately we're there to help protect them, not just to create them.
That's great. So enforcing it, let's go back to that real quick, if we may. To enforce that trademark. So again, the best thing is to come to you, let you do the research, ensure that that trademark is registered. Yeah,
so when you're talking about enforcement, that alludes to identifying someone who is infringing on your trademark. In other words, they're using your trademark, whether knowingly or unwittingly. So then at that point, it is necessary to follow up and enforce your trademark. To enforce your trademark usually starts with what we call a cease and desist letter, but they can be done, they come in different flavors. It's not a matter of saying, stop it now, or we're going to take you to court and you owe us all this money. It can be a kind, gentle letter that simply informs them that the mark that they're currently using is registered and that you're using the mark in the same area that they're using it in, and ask for an additional conversation around it. Ideally, transitions can be made. Unfortunately, oftentimes those get a little bit heated because companies have invested money at that point and developed brands. So it does help to have an intellectual property counsel, a trademark attorney who can help along that process. Once we communicate the need to stop infringing a trademark, then it all comes down to a matter of how quickly somebody needs to transition, what options are available to utilize existing product that might still have an infringing mark on it, et cetera. And those are all terms that can be negotiated.
Interesting. So again, the lesson learned, come to you first with the ideas and let you take the ball and run with it to ensure that they follow the protective process that is necessary when starting up a company.
That's right. We have some of our clients who charge us with actually policing their marks. So they have said, hey, we would like you to go ahead and identify for us any potential infringements. And so we do that. We monitor their mark and the use of their mark and identify for them potential infringers and then help them to enforce the mark. And in other circumstances, we have clients who come to us and tell us about potential infringers and say, hey, can do something about this one. We can help in both circumstances.
Wonderful. Well, it was such a pleasure to speak with you, Rob. I thank you so much for your time. Rob Wells with Rock IP, who are located in Washington, D.C. They specialize in intellectual property law. They work with their clients to help build, manage, and monetize their IP portfolios to strengthen and protect the foundation of their innovation. Thank you, Rob.
Thanks so much, Kendall.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.